See, I think what Veena ji's question is, if I understand it correctly, that a person has left a will, he has passed away, the will is coming up in a testamentary case for probate. Now, in that, can you settle in terms contrary to the will?
No, my question was, they accept the will, can they do away with the process which they have to follow in court?
Now,
Because
I would say that first of all parties to the will have to be there, all the beneficiaries. So even if somebody leaves a part of his estate to, let's say, to a trust or to a Helpage India or to a, an organization, people leave assets to completely third parties, to outsiders. As long as all of them are there and they say that we accept that this is the correct will, then you can either, as Justice Sachdeva was suggesting, convert it from a probate to a suit for declaration and close it at that. But I would always want to veer a matter like this towards settlement rather than to throw up your hands and say that just because this is a testamentary case, it is to be decided in rem, therefore there is nothing I can do. If that's what the view is, then I would discourage that view.
So I think, may I just add, if a will is accepted by all the legal heirs, a settlement is drawn up, the court can simply say that the settlement has been recorded, but can't grant a probate certificate. In case the parties insist that a certificate needs to be granted, then the will according to law has to be proved. And that is exactly what Justice Sachdeva was saying. So therefore, no, because you see, what happens in certain departments, they will want a probate as well. Although it's not compulsory, there are certain authorities who insist on a probate certificate, despite the fact that it's not required in law in Delhi. So therefore, in order to get, so the parties will have to pay court fees on the probate certificate that is eventually granted by the court after the will is proved.
Probate court fee.
Stamp duty, I'm so sorry, stamp duty. 4%. It's 4%, I'm sorry. 4% stamp duty. That's right. That's that, I stand corrected.
I won't name, but there was a sentiment where they said if the person is there alive and he agrees to certain terms and says I will write will.
That's all right.
So, sir, but writing a will.
Can you then say that you will not change it?
That's what, this is what I wanted, enlightenment on this. People close settlement on this, that he will write a will.
Why does he not give it with warm hands?
No, he cannot.
Yeah.
Their sense of insecurity. You
Yeah,
don't want
his
to
own
park.
security,
You don't.
yeah.
You don't. Your own security.
So why can't you make a settlement which kicks off, gets triggered after the person dies?
Correct. And
So the settlement-
subsequent to the settlement, if he decides to make a will, which will prevail.
No, so the settlement is his will.